Does it affect your ability to understand what's going on here?
No, sir.
All right, did you get a copy of the indictment?
Yes, sir.
It's been represented to me you're going to plead guilty to count 2, failure to comply with the order or signal of a police officer, of felony 3, and then the remaining charges will be dismissed at the time of sentencing. Is that your understanding?
Yes.
All right, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you some questions. If you don't understand a question, stop me. If you want to talk to Mr. Mulkey some more, let me know, and I'll give you more time. You understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes.
Are you waiving that right?
Yes.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
Yes.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that?
The opening
right?
minutes reveal something many people overlook about plea hearings. Before any admission of guilt matters, the court first builds a record designed to survive future challenges. Every question about age, education, citizenship, language, and medication is aimed at one issue:
In
competence.
this case, do you understand that right?
Yes, sir.
Are you waiving that right?
Yes.
If you could not afford to copy those transcripts, they'd be given to you at no cost. Do you understand that?
Yes.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any question about any of these rights?
No.
Do you still want to plead guilty to this charge?
Yes, sir.
Do you understand by pleading guilty, you're fully admitting your guilt to the charge?
Yes, sir.
You understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, sir.
In count 2, failure to comply is a felony of the 3rd degree, and that carries with it a maximum prison sentence of 60 months and a maximum fine of $10,000. Do you understand that?
Yes, sir.
Are you currently on post-release control to the parole authority?
No, sir.
Do you understand that your guilty plea in this case will result in a driver's license suspension of at least 3 years up to your lifetime?
Yes, sir.
You understand your felony conviction will prevent you from owning or possessing a firearm?
Yes.
Do you understand that if a prison term is imposed in this case, you will have to serve a period of post-release control? Is it 18 months or is it 1?
1 to 3 years.
At least 1 year up to 3 years, you'd have to serve post-release control under the parole authority.
Yes.
They will place conditions on you. If you violate the conditions, they could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If that violation is a new felony, you could get an additional consecutive prison sentence for that violation. Do you understand that?
Yes, sir.
If that were to occur, the maximum prison sentence for that violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand that if a prison term is imposed in this case, that you are eligible for judicial release?
Yes, sir.
You could be placed on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 60 months. Do you understand that?
Yes, sir.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
Do you understand I do not have to follow a sentencing recommendation of either the prosecutor or your lawyer?
Yes, I understand.
Have you had enough time to talk to Mr. Mulkey before pleading guilty today?
Yes, I did.
Has he discussed everything about your case and answered all of your questions?
Yes.
Are you satisfied with the advice he has given you?
Yes.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes.
Do you have any questions at this point?
No, sir.
Mr. DePiro, if the case went to trial, what would the evidence show?
Yeah, the evidence would show March 16, 2026, 3:38 in the afternoon, the defendant was pulled over in Lake County, Ohio, at Som Center and Maple Grove Road. Officer on duty, wearing a uniform, driving a marked cruiser, ran the defendant's plate, found that he had an active warrant. The defendant stops his car. The officer asked him to get out of the car. The defendant said, "Why?" The cop says, "You have a warrant." The defendant then put his car in gear and drove away at a high rate of speed, exceeding 60 mile an hour on Maple Grove, which is a residential street. I think it's 35 mile an hour. Speed limit at that point, and he's crossing over double yellow lines into the opposite lane to pass other vehicles, other reckless driving. The officers had to stop the pursuit. They were following with lights and sirens. But based on the defendant's dangerous driving, they had to stop it. About 25 minutes later, in Wickliffe, that was in Willoughby, Lake County, Ohio. Wickliffe, Lake County, Ohio, about 25 minutes later, on-duty police officers observed the defendant driving his vehicle completely over the left fog line into the left-hand shoulder, passing the vehicle to the left that had to move out of the way and brake so as to not get hit by the defendant. With lights and sirens, the police were following. The defendant was approaching speeds 100 mile an hour, 90 to 96 miles an hour.
The judge intentionally slows the process because every right explained creates another barrier against reversing the plea later. One unusual response briefly interrupts the rhythm, reminding everyone that plea hearings depend on clear answers rather than assumptions.
Driving across 3 lanes of traffic, fleeing from the police, and then he went on North Lakeland at 260th Street. He ran a red light at Babbitt, went back onto 90, going 113 mile an hour when the police called off the chase at that point. Thank you.
Thank you. Mr. Mulkey, anything to add to those facts?
No, Your Honor, thank you.
Mr. Thompson, did you hear what Mr. DePiro said that the facts would show if the case went to trial?
Yes.
Are those facts true?
Yes, sir.
What is your plea to count 2, failure to comply with the order or signal of a police officer, a felony 3?
Guilty.
Mr. Mulkey?
And this is that same paperwork that we went over this morning, okay? Let's sign it right here. 5/27/26. Okay. That does it.
Your Honor, the defendant, Mr. Mulkey, and I all signed the written plea of guilty form. With the court's permission, I'm approaching to present that form to Your Honor.
Mr. Thompson, is this your signature on the written plea of guilty?
Yes, sir.
Did you sign it voluntarily?
Yes, sir.
Do you want me to accept your written plea of guilty?
Yes, sir.
I'll accept the written plea of guilty. Defendant was present when Mr. Mulkey advised of all of his rights, made a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. Will accept the plea of guilty and find him guilty of count 2. Failure to comply, a felony 3. I'll refer this for a pre-sentence report. Sentencing will be July 1 at 1:30 p.m. Mr. Mulkey.
Yes, Your Honor. As it relates to bond, my client would like the opportunity to be released on a recognizance bond. I believe he understands that if he fails to appear for court, that would involve a new felony charge, a felony 4 action for not showing up to court. He, as he indicated, has experience as an HVAC tech. He's a member of Sheet Metal 33 Union. He also is willing to pursue work as a welder upon his release. My understanding is he does have 5 children, ranging from ages as old as 16 years old to as young as 2-year-old. He'd like to continue to be able to provide for them. He's willing to wear a GPS monitoring system, appear at all future court appearances, cooperate fully with probation for a pre-sentence investigation. He's being properly medicated, taking his Lexpro. He does well when he's taking his medication. He wants to maintain a clean and sober life. He has a residence at 372 Haley Drive in Euclid, Ohio. He resides there with his mother. Judge, thank you.
Shapiro.
State opposes that request. The bond is set at $200,000, cash surety of the conditions of GPS monitoring, EMHA, and no driving, which is warranted based on the conduct here and the facts of the case, the nature of the offense. The defendant does have prior felony convictions, F3 burglary, where he got in Cuyahoga Common Pleas Court, where he got community control in 2021 with CBCF treatment. In 2017, here in Lake County, he was convicted of an F3 tampering with evidence, served 14 months in prison. Prior to that, he has resisting arrests, unlawful transactions and weapons, a misdemeanor, failure to comply. Actually, if he has a misdemeanor failure to comply, does that make this a mandatory lifetime driver's license suspension?
That's my understanding.
Was that on the paperwork? I didn't catch that part.
Once the penalties are explained, the case shifts from legal theory to public safety. The court is no longer discussing paperwork, but the real-world consequences attached to this offense. Questions about license suspension, firearms, post-release supervision, and possible future violations show that punishment extends well beyond prison time.
So that would have to change. If he's got a prior failure to comply, I don't know if it's a felony or not. I'm going to look that up right now.
I've been through this once before, and there's no distinction made between a felony and a misdemeanor failure to comply.
No. 2021
It's a lifetime driver's license suspension because you have a prior failure to comply. Okay. All right.
Yeah, it would be 2921.331 subsection E.
Is that still a class 2 or is it a different classification?
Well, it says, you mean it's class 2. It's a class 2, which is 3 to life, 3 years to life, as it states in the paperwork. What I'm worried about is, about midway down, it says, if the offender previously has been found guilty of an offense under this section, in addition to any other infraction, the court shall impose a class 1 suspension under 4510-02A1, which I believe is a lifetime suspension. We're going to look it up right now. Yeah. So this paperwork, Your Honor, I would ask the court to advise the defendant that his driver's license is going to be suspended for his lifetime because of this conviction. And we advised him based on what we had in here, that it was a 3-year to life driver's license suspension, but that is inaccurate. It's actually a lifetime suspension.
You understand that, Mr. Thompson?
Yes, sir.
It's a mandatory lifetime suspension. Mr. Mulkey, I'd ask you to take this back. And at the bottom of page 2, you have Mr. Thompson initial in the margin.
He does. Do you want to verify that your client does have this misdemeanor failure to comply in Willoughby? I mean, I'm just seeing a note. I'm not looking at leads.
All right. And so there's just the judge wrote what medications you're on, and this says lifetime suspension, so the initial that there.
So suspended for life.
I'm looking at a note in the file, Judge. It says M1. I'm not looking at
you
a
can
lead.
initial right there.
All right, well, if
I can't get my
if
license.
it turns out that that's not the
You
case,
cannot.
then it'll be a Class 2.
Thank you, Judge. Thanks. Did you guys initial that? Is that what that is?
Yeah, something, and then that's his initials.
Okay. Your Honor, the defendant and Mr. Mulkey initialed where you crossed out and wrote a lifetime suspension. So did I. I'm approaching to present it to you, Your Honor.
All right, based on this offense and the history as indicated by Mr. DePiro, I'm going to revoke the defendant's bond.
Pled guilty and been found guilty of 1-count felony of the 4th degree failure to appear on an OR bond. Parties are ready to go forward, Your Honor.
Thank you. Mr. Smith, go ahead.
Thank you, Your Honor. First and foremost, my client takes full responsibility for both cases here. Definitely realizes he didn't use the best judgment in the first case and not appearing for sentencing on an earlier day like he should have. And as a result, he picked up a new case for failure to appear. So he takes
After guilt is formally accepted, the conversation immediately turns toward risk instead of remorse. Defense counsel understands that sentencing is still weeks away, so the immediate objective becomes securing release before that hearing. Every point raised serves that single purpose.
He takes full responsibility in that, realizes that he should have made any and all efforts to come to court when he was supposed to for sentencing. We're asking for fines and court costs, number one, time to pay for that. And I do think my client could benefit from some sort of drug or alcohol treatment. He does understand that that will involve more local time, quite possibly in regards to that. We're asking if he be placed on probation, if that probation be transferred to his home state, which is New York. He's indicated to me that after all this is behind him, he plans on going back to New York. Thank you.
All right, thank you. Mr. Harvey, what do you want to tell me before I sentence you?
That I'm happy I'm here getting this taken care of. You know, I made some bad decisions, and you know, I'm just happy to move on with my life and start new. You know.
So your history indicates a conviction in 2014 for drugs.
Yes, Your Honor.
You were put on probation with conditions that you completed probation in July of 24, and then you pick up this case in 25. So what's been going on? Usually I see drug guys that are 1, 2, 3, 4, 5
Yeah, no,
continuously.
I got caught up with in the streets. I lost a couple friends. I started smoking crack a little bit, and then I moved out here to get away from all that shit, and I did. Oops, I'm sorry. Mind my language. So then I got caught up in the wrong place, the wrong time. I succumbed to, you know, purchasing the drug again, and I got caught, you know, with it. So, I mean, I haven't touched nothing else since then except a little bit of meth, and that was why I had a bad tox. Other than that, I'm done with all that stuff. I've been clean since. My girlfriend, she's clean. My family's waiting for me to get out of this so I can go back to work with them. And, you know, I miss my old life and I miss my friends, but I can't bring them back by doing drugs. So I've
How
learned
many
a
have you
lot.
lost because of this stuff?
I lost my car, my apartment, my way of life, some respect for myself. You know, luckily I still have my family.
What about people? Have you lost friends? You mentioned something like that.
Yeah, I've lost a couple of friends. They had an accident. Like one had a motorcycle accident, a traumatic brain injury. Not to do with the drugs, but that's what kind of pushed me into the spiral that I caught myself in. And then, but I've grieved, I've recovered. You know, I got my life back on track, and I'm still sorry that I didn't make it to court. I needed a little bit more time, but I realized that my bond was revoked because of the dirty talks, and I didn't know that, or else I would have turned myself in a little earlier. And I guess that's the only reason I didn't do that is because I didn't have an active phone on, and I was trying to get one, and I wasn't able to contact my lawyer 100%. So that's on me still. You know
What do you have to do to get your driver's license back?
I have to pay, I think, a $40 fee in Portage County and a $60 license suspension fee, I think, in another county of Ohio.
The second case introduces a completely different defendant and a completely different courtroom dynamic. Unlike the earlier hearing, the discussion centers less on dangerous driving and more on personal accountability after failing to appear.
And then I think I have a $175 fee in New York for my suspension there. If that's correct. I'm going to get all the information I can as soon as I get out. I mean, work with my probation officer as well and try to get all my court costs and fees taken care of. My dad set a little bit of money aside for me to take care of some fees and such like that, as far as transfer and a ride home and to get me set up, you know, when I get back home, if and when that happens.
All right. Mr. DePiero?
State's going to join in the recommendation for community control sanctions here. We hope the defendant does get his life in order and his affairs and his addictions dealt with. If not, he can sit and rot in prison. Thanks.
All right. I've reviewed both pre-sentence reports and the drug and alcohol evaluation from last fall. I've considered all the provisions on 29, 11, 12, and 13. On both cases, I'm going to place you on community control for 3 years. On the 916 case, you're going to serve 93 days in jail with credit for 48. The last 30 days, you're going to enter into the jail treatment program, complete it, and follow their recommendations. On the 1493 case, 78 days in jail with credit for 78. The remaining terms will all be concurrent on community control. When you're done with the jail treatment program, you're going to enter into the NeoCap program, complete that, and follow the recommendations. You're to have no drugs or alcohol, and you'll be screened. You're to attend at least 4 AA or NA meetings a week and obtain a sponsor and maintain a sponsor. At the appropriate time, obtain and maintain full employment, get a valid driver's license, and pay the costs and supervision fees in these cases. Ms. Wehagen, any other terms you think are applicable?
No, Your Honor, thank you.
All right. Mr. Harvey, do you understand the terms?
Yes, I do, Your Honor.
If you don't comply with the terms, then the state will file a motion to terminate your community control. If I find you violated, you face a potential prison sentence of 18 months on the 1493 case and 12 months on the 916 case. You understand that?
Yes, Your Honor.
Now, if you, assuming you go through the jail treatment program, complete it, go through NeoCap and complete it, then I will likely transfer your supervision to, what county do you live in New York?
Niagara County, sir.
Niagara County. So that's the likelihood if you do what you're supposed to do.
Okay.
Anything else, Mr. DePiero?
Was there any discussion of forfeiture either? If there was any contraband drugs? we
Yeah,
would-
anything subject to forfeiture is forfeited to the
Thanks, sir.
state. Anything else, Mr. Smith?
No, Your Honor.
All right, we're adjourned.
All right, thank you. Okay, go up. Go up.
Okay.
Yeah, you're free to go. We'll do it.
The defendant's explanation becomes stronger because it avoids presenting himself as completely blameless. Instead of claiming that life forced every decision, he openly connects grief, addiction, and personal choices without pretending those factors erased responsibility. That distinction matters in court. Judges regularly hear stories of hardship, but they look for evidence that someone understands the difference between a reason and an excuse. The sentencing decision reflects a calculated balance between accountability and opportunity. Community control is not presented as mercy, but as a structured test with measurable expectations. Jail treatment, rehabilitation programs, frequent recovery meetings, employment requirements, license restoration, and financial obligations all work together as interconnected conditions. Each requirement addresses a different risk factor instead of relying on punishment alone. The court is effectively building a framework where success depends on consistent daily decisions rather than one emotional promise made in a courtroom. The prosecutor's blunt warning reinforces that philosophy. Hope is offered, but consequences remain close behind. This sentence gives the defendant a path forward while making it absolutely clear that continued freedom depends entirely on his own actions. The hearing ends with a practical reminder that rehabilitation is earned through performance, not intention. The judge even leaves open the possibility of transferring supervision closer to the defendant's home state, but only after treatment and compliance prove that trust is deserved. That conditional promise reveals how courts often encourage cooperation without guaranteeing rewards in advance. Every future privilege is tied directly to verified progress. Final discussions about forfeiture and remaining procedural issues may sound routine, yet they emphasize that every legal loose end must be resolved before a case truly closes. By the time the defendant walks out, the courtroom has replaced uncertainty with a detailed roadmap. Whether that roadmap leads to recovery or incarceration now depends entirely on choices made outside the courthouse.